The committee agrees that the questions that Senator O'Neill is asking are relevant to this round of Senate estimates, including the topics that she is exploring around, for example, handling of sensitive information. She is entitled to ask those questions. The Minister is entitled to provide answers to questions as he sees fit when he wishes to answer a question. I draw the Minister to the topics of the question and invite the Minister to refrain from talking about any member of the House of Representatives' private interests in any answers that he may give. And on that understanding achieved by the committee, I call Senator O'Neill to continue her questions.
I might
Senator
just conclude
O'Neill.
my answer reflecting on that advice. Thank you, Chair. In terms of, I think Mr Longo has explained Asic's role in terms of prosecutions. Of course, in terms of individuals who work for Asic or Treasury or the public service more broadly, or public office holders, including members of the House of Representatives or senators, it is the case that individuals become privy to information that they have a duty, not just in terms of the criminal law and civil law, but they have a duty to the people who they serve to not use that information in any way but for the public purpose for which it has been provided. That it is not an opportunity to enrich yourself or to trade shares or to undertake activity that goes to one's private interest. And of course, that both the period that we've recently gone to around the global financial crisis, but also latterly the intervention that the Morrison government undertook with the support of the then opposition are good examples of concentric rings of people being engaged in having knowledge of imminent public sector interventions that will change the market. And in the absence of that knowledge, ordinary Australians who, during the COVID period, of course, we saw long queues at Centrelink's, high levels of uncertainty. During the global financial crisis, markets being smashed around the world, banks collapsing, factories closing, economies going backwards, that it was by no means a certain thing. Maybe in retrospect, people say astute investments at the time, by no means a certain thing when critical interventions were going to be undertaken or whether they were going to be undertaken. And so all of those, people in the Australian public deserve to know that their representatives are acting in their interests and their interests alone. That's why the government has, of course, on coming to office, put the Ministerial Code of Conduct, which imposes higher obligations upon ministers than previous governments imposed. But in any case, there are criminal and civil tests, but there are public character tests that should be applied to members of Parliament and public office holders more broadly. Thank you.
Senator O'Neill.
Thank you very much, Minister and Chair. So if I can pick up the threads of where I was before the private meeting, I asked, could information relating to policy development be considered market-sensitive information? I think Senator Ayer's contribution has made it very clear that that is the case. I was about to read from the privileges document a description of the behaviour of Mr Gretsch at the time, who was leading the policy work as a senior Treasury official of a program entitled the Australian Investment Business Partnership, which was essentially to invest $4 billion to shore up the banks and security of the banks for Australia in the crisis that was emerging under the GFC. So it is now a matter of fact and recorded in this document. I'll quote from it. Documents and emails recovered from the Treasury IT system indicate that Mr Gretsch was active during normal business hours in corresponding with third parties on issues of a political nature and outside his core work responsibilities. I read some of those onto the record yesterday. There was no dispute that he was he described himself as a Lib. He was communicating with members of the Liberal Party. That is shown by the addresses that he communicated with. Given that, it is unknown at the moment exactly with whom Mr Gretsch communicated this market-sensitive information. But my question to you is, how would such sensitive information be considered picked up now? You've indicated a couple of techniques you have. And would information of the kind that Mr Gretsch was sharing have been picked up at the time by the ASX, who you indicated were the custodians of the insider trading matters at that time?
At that time, the ASX, if we're talking about, 2009, I think, clearly the ASX was the frontline regulator. But right up front, Senator, with great respect to the committee, I'm not in a position to comment on whether or not the information this person had was price sensitive in the sense that that concept is understood for the purposes of a potential insider trading prosecution.
You would have to do a lot more investigating.
I think it's really important that, with your indulgence, we're very important to be very objective about the language we're using. There's clearly lots of information that we talk is market sensitive. It's confidential, it's market sensitive, it's interesting, it might move the market. We often hear that phrase, move the market, and markets reacted. And that's fair enough. I think we have some sense of what that means. But market sensitive information and trading on it ahead of that information being published or made known isn't necessarily information that's going to prohibit you from trading because there's so many factors that go into an insider trading prosecution. So we talk about market sensitive information, as I've already mentioned, in any criminal prosecution, that information has to be particularised to a very high standard, and there are lots of court cases about that. I can personally attest to that. Secondly, in order for the prosecution to even get this matter to a jury, the Crown, usually the prosecution, normally has to lead expert evidence to establish or to opine that what the prosecution says is price-sensitive information is price-sensitive. So the court and the jury, if it ever gets to a jury, will not take the word of the prosecution. The court will expect there to be expert evidence. And I can tell you now that expert evidence is often contested by other expert evidence that says that the information is not price-sensitive. So I think it's really important for the committee to sort of appreciate that from my perspective, from Asic's perspective, the information may be confidential, may be market sensitive, it might be interesting, but that doesn't, and people might know it at the time they do some trading, but all that has to be linked back to the particular entity in which the trading of securities occurs, and there's lots of hoops to jump through along the way. So I really want to stress those general principles because I really can't comment on this gentleman's state of knowledge and who he spoke to and all of that. I just can't do that, Senator.
Perhaps you're not the person who needs to come forth with the truth about what was going on there. There are members of the Liberal Party, though, who know exactly what it was that Mr Gretsch was communicating to them at the time, and I believe it would be in the national interest if people of integrity who had that information and didn't use it, were able to inform the current interest. And of course, it would also, it would seem to me appropriate that if there was somebody who advantaged themselves in that period of time between the 23rd of February, when the market was at its lowest, and the day of the announcement of $4 billion to prop up the banks, with a 21% increase over 12 days, in the following 12 days, who had intimate knowledge of that, that would be important to put on the record too, especially if such a person was still in the public eye. Could I just ask a couple of quick general questions? Do you monitor for unusual share activity related to government announcements now?
My understanding of the way the system works is that we have technology and systems and processes where we look at what's going on in the trading in the market, and so that technology will lead wherever it leads. So we have the identifiers for who's actually doing the trading, and without going into sort of information that's actually quite sensitive, we have capability to trace who's behind the trading and form quick judgments about whether we need to ask more questions or whether we're satisfied that the initial reaction to our questions. Remember, we get hundreds a day. Our team's very experienced. We're on the constant communication with the ASX and with brokers. So it just depends. So we actually don't have, we're interested in everybody's trading. We don't give special attention to one part of the market or over. You're trading on the Australian Stock Exchange, we're watching.
Thank you. Final question, if I can. If it was found that an official involved in the development of key policies responding to the global financial crisis had been leaking sensitive information that was capable of affecting the market, that was generating a practice of insider trading, would that raise concerns for you about these historic occurrences? Would you have the capacity with the ASX to investigate if you were so inclined?
Senator, I hope you don't mind me saying this. I'm not going to comment on a particular scenario, but as a general principle, ASIC stands for transparency. We've just published a paper on public and private markets. It is a fundamental tenet of well-functioning markets that there's transparency, because that leads to honesty and efficient markets, honest and efficient, transparent markets. So as a general principle, unless there's a good reason to keep something confidential, our system encourages information to be made available to everyone. That's really at the heart of the continuous disclosure regime. There are obviously exceptions that I won't go into now, but as a general principle, we celebrate transparency, and unless there's a good reason, and there often is, you're developing confidential policy, or it's proprietary nature, or it comes under one of the exceptions the ASX recognises, but as a general principle, of course, we encourage openness. Now, around the GFC, there's lots been written and said about that. I think for today's purposes, if it's okay with the Chair and the committee, I think from an ASIC perspective, we encourage transparency. But of course, all of us appreciate the need for confidentiality in our work.
And the integrity of people who come across confidential information, whether it's in their direct control or whether by the rumour mill they pick up a hot tip on the horse that's running tomorrow at the ASX.
I don't know anything about horse trading, I'm sorry, horse races. But I think we can agree that the basic principle is, I think for those of us who have been around a while, appreciate basic concepts of confidentiality that we're talking about. And there's obviously lots of potential questions around information that should be kept confidential, that's market sensitive, that's going to move markets. But these are very general concepts. And from the humble world of ASIC, we are here to enforce the insider trading laws. If information comes to our attention that would justify the commencement of an investigation, then that's what we'll do.
Thank you very much.
Yeah.
I've got other questions, Chair. Thank you.
Thank you. So just some housekeeping. We're due to break at 12:10 for lunch, which we will do. A number of senators still have questions. So we will be returning after lunch with Asic, and I'll go to Senator Rennick.
Cheers, thanks, Chair. Hi, guys. How you going?
Good morning, Senator. I can still say good morning. It's not quite
just
lunchtime.
2 minutes. Look, I just want to congratulate you on the fact that you've raised this issue about transparency in opaque markets.
Yes.
Because I've long had an issue with opaque markets, but one of the reasons why I think these dark pools have been created and the way they get around it is that when the GST was introduced, the state governments got rid of stamp duty on share trading. And I actually think if you wanted to actually kill a lot of this scalping and opaque market stuff, you need to bring back stamp duty on share trading. I know, well, if you think about it, we pay stamp duty. I mean, I know you're not responsible for policy, but just in terms of dealing with it, because, you know, hard-working Australians pay stamp duty on their houses, on their farms, on any hard assets they buy, you know, often still stamp duty on insurance, for example, and yet we have these high-frequency traders, most of them foreign sourced or residency, coming in here and if you take the fact there's no stamp duty on share trading, combined with the Tax Act that actually gives an exemption, a capital gains tax exemption on foreign companies who engage in, who own less than 10%, so they're called a non-portfolio interest, they don't have to pay capital gains tax. So it's a right market for money laundering because they don't have to pay stamp duty on the way in, they don't have to pay capital gains tax on the way back, and it's completely opaque. So I congratulate you for looking at it. I think it's a very serious issue and I think something has to be dealt with. I just want to come back to, so that's more of a comment, I guess, but keep it
Thank
up.
you, Senator.
Because, and Minister, I might recommend that to you, if you've got a productivity crisis in this country, bring back stamp duty on the share trading and encourage and fund the states to abolish payroll tax, because that would really help our corporate sector a lot. Because it's ridiculous we have payroll tax on people at work, but yet we have foreign scalpers and traders come into this country trading, you know, shares in our assets and pay nothing. But just the other question I've got for you is, I raised the issue last time of Macquarie Bank getting fined a few $1 million for engaging in scalping the energy markets. And I believe that was a civil conviction, if I'm...
I think that's correct. It was a penalty imposed by the Market Misconduct Tribunal, I think is the name of the tribunal. So it wasn't a court, but it's one of those interesting entities created by the Corporations Act.
Yeah, okay, thanks, because I just...
Thank you. My deputy is Market Disciplinary Tribunal.
The disciplinary panel.
Right.
MDP.
But not a court.
Okay, cool. I note, however, that there are a couple of smaller people. One was a nurse, I think, that got charged. Did they make? Yeah, they made a profit of $88,000 for, you know, what do you call it, spruiking shares on the market, and they were criminally charged. And I just note, I think there's a difference in outcome there. While obviously I don't condone what they did, you know, they made it was the four people that made $88,000. It was out there somewhere about $22,000 a pop. They're going to be criminally charged, and I, you know, I think there's plenty of spruikers out there on hot copper and all that all the time. But I just think that there was a, you know, it's unfair that the individual gets a criminal charge, yet Macquarie Bank only gets a civil charge. I'll just leave that. I don't know if you've got any comments on that as well.
Are we familiar with that particular matter that the Senator is raising?
I'm not familiar with it. Sitting here now today, Senator, but I understand the broader point that, as I understand you're making, that individuals get criminally charged and criminal convictions, and that a big entity like Macquarie is getting a $5 million civil penalty, but not the condemnation, if you like, that comes with a criminal conviction. So I understand the point.
And because that touches on Senator Bragg's point before, you know, you've got to put it, because, you know, there's so much going on, it can't get over the top of every, you know, thing, you know, bit of corruption or whatever, or cheating on the markets or whatever. But if you put a couple of them in jail, I think you'll find just the fear of actually real penalties being applied to these people will suddenly, you know, rein them in a bit. But I'll leave that as a comment as well.
Could
Thanks,
I, just with your leave, Chair, just very quickly, because over the break, Senator Bragg asked me about the number of custodial sentences in the last 12 months, and I haven't got the 12-month figure, but I've got the 6-month figure and there's 11 custodial sentences that have been imposed on people for misconduct. That includes suspended sentences where the court makes that decision, 8 the year before and 21 the year before that. So we can still give you that information further if you need it, Senator Bragg, but there are a lot of people in custody as a result of ASIC investigations.
Good.
It's a good segue back to Senator Bragg.
So I just want to follow up on a few things. So I think, thank you very much, Chair. So I think we've now tabled the document in relation to the Australian super matter.
Yes, I have it, Senator.
There's an extract and maybe also the whole judgment. So can I ask you, in relation to the trustee risk reserve, who funds that?
As I understand it, Senator, it's not my direct area of expertise, but I understand that is the members fund that through fees, and they fund a range of other administrative and other costs of the trustee.
Okay, and then the trustee risk reserve is used for paying regulatory fines, perhaps?
Yes, as I understand it. Again, Senator, I caveat my answer only in that I'm not an expert on how these issues work, but that's my understanding.
Okay, but generally speaking, the members have built up the reserves in the fund through paying higher fees. That is then reserved.
I don't know if they pay. Sorry to interrupt.
For future
Senator.
purposes.
Yeah.
And then in the case of the judgment here, as it says, as you know, in your own hand, Australian Super maintains a trustee risk reserve. And so then...
sorry, Senator. Again, I'm not trying to be argumentative. This is not in my own hand, in ASIC's own hand. This is a judgment of the federal court written by a judge. Now, it will draw heavily on facts agreed between the parties put to the court. I don't demur from that at all, but I just want to be clear, this is an excerpt.
But didn't you agree with the judgment?
Submission or the judgment?
No, I think this is the... I'm so sorry, Senator. We're just trying to ascertain. I've assumed that this is an excerpt from the judgment of the federal court.
Yes,
that's right.
It is.
It's
yes.
It's not from the joint submissions of the parties.
No, it's a judgment. Okay.
Yeah.
Okay. And you generally were happy with the judgment?
We were...
These are not trick questions.
What's that?
These are not trick questions.
No, I was just trying to think about... Well, we're certainly... it's an interesting description, Senator, happy with the judgment. We think that the imposition of the penalty amount was appropriate in all the circumstances of this misconduct.
So I'll just take the opportunity to table the document formally that Senator
Chair.
Bragg is referring to, and also the opening statement as well.
Thanks, Chair. So then, I guess just going back to my earlier question around the size of the fine, as I said, it could have been as high as $140 million, and it seems to me, and now you have the paper in front of you, that one of the factors that was taken into account was the status of the capital position of the fund, that it had been funded by members who had created the trustee risk reserve. So is this a factor that you imagine you will take into account when you are in a similar situation in future, for example, in relation to, I don't expect you to make direct comments about these matters, but in relation to REST insurance issues or C-buses issues, that they are of a similar capital status in that the shareholders do not put capital into the fund, the members pay a fee to build up a risk reserve. So do you expect this to be something that ASIC will take into account in future?
The provisions of the legislation require ASIC to take into account the effect of the penalty on members. That's an express provision in the law. So yes, clearly that will be one of many factors that are taken into account in relation to ASIC submissions on penalty to the court. Ultimately, the court will determine that issue, Senator.
Because the higher the fine,
going after them.
because the higher the fine, the greater the fine, the more the members pay.
The higher the fine... Well, again, Senator...
The members pay the fines, right? They pay it through the risk reserve.
Yeah. The members don't directly pay the funds. There is the penalties. The law prohibits that. These penalties can be, as I understand it, sourced from a range of areas, including a risk reserve, including insurance, and there may well be other issues as well, Senator. Yeah. So the effect of the penalty on members is one aspect a court will take into account. Against that, Senator, can I just be clear? ASIC has been working very hard to increase penalties across the board in the financial services sector, and this was a significantly high. I think it's the second highest penalty that has been imposed on a superannuation fund. Again, I stand to be corrected on that, but it's a significant penalty, and in our view, it was appropriate in the circumstances.
Okay, you've made your position clear. I won't add any editorial, so thank you for that. I just want to ask about phoenixing, Chair. Thank you. So we have canvassed these issues with ASIC before about phoenixing. So I wanted to ask you about the Dalma case. Is anyone able to talk to me about that?
Could you give me any more information, Senator? It's not a name I'm familiar with.
It's about payroll.
I'm sorry, Senator. It's not triggering or ringing any bells for me, I'm afraid.
Okay, so I might make some more general comments and maybe you can answer my question this way. So how confident are you that when someone is rubbed out as a company director or has faced a serious penalty, that they're not going to turn up again as a company director?
How confident are we?
Yeah, in your systems that ensure that if people are banned, that they don't end up being directors.
Well, look, I'm reasonably confident, Senator. I mean, we have got a lot of work that goes on in relation to directors. We engage all the time with liquidators. We are getting reports of misconduct from businesses and from liquidators on a regular basis. We follow all of those up, every one that we receive. So we have been working very hard to make sure that the requirements of the director ID requirements are being met, and we've now got very high compliance in terms of the directors and the director ID, and we are having prosecutions of directors that we are ascertaining have not complied with those requirements. So there is a lot of work going on in relation to these issues.
Can I ask you about a matter concerning someone who I believe was banned as a director, Terence Marshall? You might need to take this on notice, but
I think I might have to.
I understand that Mr. Marshall may have ended up becoming a company director again after he was banned and perhaps during his banning period. So could I don't expect you to know the details of the cases here at the hearing, unless you have anyone who can provide that on notice.
I don't think we have that, anyone here with that information, but
okay.
Senator, clearly, well, we being banned from being a director is serious. If we get information that somebody is acting as a director during the period of their ban, then that's something we would look at seriously and be very happy to have that information.
If you could look into that and provide me with an answer as to what has happened in this case.
Do you have any more details, Senator?
I understand that there's correspondence in your system from Mr. Warren Day. When he was there, he exchanged some correspondence with some people who had been in some way engaged with the gentleman I mentioned before.
Sorry, I know you're asking me questions, Senator. Could I just ask, is that recent correspondence from Mr. Day?
Yes, it is, within the last 18 months.
Okay, thank you, Senator.
Yes, thank you very much. Just finally, then I'm done, Chair. Can I ask you...
Actually, thank you for checking with me, Senator Bragg, because we are due for the lunch break. So we will take that break. We'll resume with ASIC, and the time that we will resume is, Secretary?